The letter arrived on a Thursday, folded once too many times, its edges softened by hands that had carried it through decades before finding mine. I almost tossed it aside with the rest of the mail utility bills. A grocery flyer. A notice from my bank because nothing in my life suggested that something extraordinary was about to surface. I was a consultant, mid-career, renting a modest house and measuring my ambitions carefully, the way people do after learning how fragile plans can be. Estates and inheritances belonged to other families, other stories. Mine had always been simple, even sparse. Yet, inside that envelope was a revelation that quietly rearranged everything I thought I understood about ownership, power, and how far institutions will go when they believe something should belong to them. The letter informed me that my great-uncle Harold, a man I had met only twice and remembered mostly as a sunburned silhouette at a family reunion, had passed away. That alone was not shocking. Harold had been old when I was young, and the years since had not been kind to anyone. I read the letter 3 times before calling the attorney whose name was printed at the bottom. Sounded unsurprised when I stammered through my questions as if people called him every day to ask whether they really owned a lake. Explained, patiently and with the cadence of someone used to disbelief, that I did not own the land surrounding the lake, nor the lake bed itself, but the rights to the water usage, access, withdrawal, and control granted decades earlier under a complex patchwork of state water law. Harold, it turned out, had been meticulous. While others bought cabins and shoreline lots, he had purchased the rights everyone else overlooked, then protected them with almost paranoid care. The lake, the attorney continued, was now encircled by a large, well-funded homeowners association. Over the years, a development had grown up around the water, marketed as a private paradise with docks, boats, and manicured views. The HOA managed everything above the waterline: roads, utilities, landscaping, and the carefully curated image of exclusivity they sold to new residents. What they did not own, and what many of them did not fully understand, was the water itself, that belonged, legally and unequivocally, to me. When I finally visited the lake, it was early autumn. The surface broken by migrating birds and the lazy arcs of fishing lines, cast from docks that extended like fingers into water they did not control. The development was beautiful in the way planned communities often are, symmetrical, clean, and slightly unreal. Large homes sat behind gates and hedges, each one angled for a view of the lake. There were signs everywhere reminding residents of the rules. No overnight guests without registration, no boats above a certain horsepower, no swimming after dusk. It was order presented as serenity. I felt like an intruder even as I reminded myself that, on paper at least, I held a form of authority no one around me could see, that invisibility was part of the problem. When I introduced myself to the HOA board, their initial reaction was polite confusion. They had assumed the water rights were either communal or irrelevant, a historical footnote that no longer mattered in a modern master plan development. One board member even laughed, telling me that the HOA had been managing the lake for years without issue. Another suggested kindly that I sell whatever paperwork I had and be done with it. What they did not realize was that water rights are not symbolic. They are enforceable, powerful, and in times of scarcity, invaluable. Harold had understood this long before it became fashionable to talk about water as the new oil. His journals, which the attorney later shared with me, were filled with notes about rainfall, evaporation rates, and the creeping expansion of developments that treated natural resources as amenities rather than systems with limits. He had anticipated conflict not because he was combative, but because he knew how easily convenience turns into entitlement. Within weeks of my visit, the tone changed. The HOA's legal counsel contacted mine with an offer to purchase the water rights outright. The number was generous, more money than I had ever seen attached to my name, and for a brief moment I considered accepting it. Life would be simpler without this unexpected responsibility. But simplicity has a cost, and as I learned more about the lake, the ecosystem it supported, and the casual way the HOA spoke about expanding usage to attract more buyers, that cost became clearer. I declined the offer. That refusal marked the beginning of a struggle that would expose not just the HOA's assumptions, but the fragility of systems built on those assumptions. They believed that because they had managed the shoreline, because they collected dues and enforced rules, the water was effectively theirs. They believed, perhaps unconsciously, that an individual could not stand against an institution designed to persist. What they underestimated was the law, and the quiet strength of rights established long before their development ever broke ground. As months passed, small conflicts surfaced. The HOA announced plans to increase water withdrawal for landscaping during the summer. I reminded them, formally and in writing, that such usage required my approval. They ignored the letter. Boats multiplied. Docks extended farther into the lake. The association behaved as if my refusal had been a temporary inconvenience rather than a definitive boundary. Each overreach was documented, each violation noted, building a record that would later become impossible to ignore. I did not set out to dismantle an HOA or to deprive families of the lake they loved. My goal was narrower, and in my mind, reasonable. Respect the rights as they existed, manage the water sustainably, and acknowledge that ownership is not a feeling, but a fact supported by law. The tragedy for them was that they mistook restraint for weakness. In doing so, they pushed a conflict that might have been resolved quietly into the open, where consequences are less forgiving. By the end of that first year, it was clear that coexistence would not be easy. The HOA escalated, filing for declaratory judgments, attempting to assert control through sheer persistence. Each move they made revealed how little they had prepared for the possibility that they were wrong. And as I stood on the shore one evening, watching the sun sink into water that now felt both ancient and contested, understood that inheritance is not always a gift. Sometimes it is a responsibility that asks how much you are willing to endure to defend what was entrusted to you. The first formal notice from the Homeowners Association arrived by certified mail, thick with legal language and thin on humility. It asserted that the HOA, by virtue of decades of uninterrupted management and the financial contributions of its members, possessed de facto authority over the lake. The letter avoided the phrase water rights whenever possible, substituting softer terms like stewardship, its customary use, and community reliance. It was an argument built less on law than on expectation, as if repetition alone could transform assumption into ownership. My attorney read it once, sighed, and set it aside like a child's drawing pinned to a refrigerator, not without affection, but not with any expectation it would hold up under scrutiny. The HOA's confidence was unmistakable. They were accustomed to compliance. Their rules governed paint colors, fence heights, holiday decorations, and the acceptable angle at which a boat could be moored overnight. Residents paid their dues, signed their acknowledgments, and rarely challenged decisions because the cost of doing so was social as much as financial. The board meetings were orderly affairs where dissent was managed politely, then buried in committee. Against that backdrop, the idea that a single individual could veto their plans for the lake felt, to them, not just inconvenient but offensive. They began by testing boundaries. Without seeking approval, the HOA contracted a landscaping firm to increase irrigation along the shoreline, drawing directly from the lake during the driest part of summer. When confronted, the board claimed it was an emergency measure to prevent erosion and protect property values. I responded with a CI Sandicist letter, carefully citing the statutes that governed consumptive use. The water withdrawals stopped briefly, then resumed at night, quieter, but no less real. It was my first clear lesson that overreach often arrives disguised as necessity. At the same time, the association launched a public relations campaign within the community. Newsletters framed me as an absentee heir with no real connection to the lake, someone who inherited paperwork rather than responsibility. They warned residents subtly at first, then more directly, that my insistence on legal compliance could limit recreational access, reduce property values, and threaten the lifestyle they had been promised. Fear is a powerful organizing tool, and the board wielded it skillfully. Soon, I was receiving letters from homeowners I had never met, accusing me of greed, of holding the lake hostage, of not understanding how much the water meant to their families. What those letters revealed more than anything was how thoroughly the HOA had allowed residents to believe the lake was theirs. Marketing materials from earlier years described it as community-owned, a phrase that was aspirational rather than accurate. Sales agents had gestured broadly at the water during tours, implying permanence and control, without ever explaining the underlying legal structure. By the time I entered the picture, that implication had hardened into belief. To challenge it felt to many like an act of betrayal. The board escalated again. this time filing a lawsuit seeking a declaratory judgment that their long-standing use of the lake constituted an easement by prescription. It was a bold move and one that revealed a fundamental misunderstanding of water law. Prescriptive rights are difficult to establish under the best of circumstances, and nearly impossible when the use in question has been permissive, documented, and subject to periodic objection. Harold's records showed decades of correspondence with the association's predecessors, granting limited use while explicitly reserving control. The paper trail was extensive and, from a legal standpoint, devastating. Yet the HOA pressed forward, buoyed by the belief that litigation itself would wear me down. They assumed I would settle to avoid the cost, the attention, the disruption to my life. Did not. What they did not account for was how their tactics had shifted the stakes. This was no longer about a quiet transfer of rights or a mutually beneficial agreement. It was about precedent. If they succeeded, it would signal to every large association that persistence could override clear title. That was not something I was willing to concede. Discovery was where the HOA's internal contradictions began to surface. Emails between board members revealed an awareness uncomfortable but undeniable that they did not legally own the water. One message sent years earlier warned that the water rights issue could become a problem if ever challenged. Another discussed the cost of purchasing the rights outright, concluding that it was cheaper to operate as if we already control it. That phrase would later appear on a courtroom screen, enlarged and impossible to explain away. As depositions proceeded, board members struggled to reconcile their public statements with their private knowledge. They spoke confidently about stewardship, then hesitated when asked to define its legal basis. They described the lake as essential infrastructure, then admitted they had never verified ownership because it was assumed. Assumptions, it turned out, were the foundation on which the entire development had been built. When those assumptions were questioned, the structure began to wobble. Outside the courtroom, tensions within the community intensified. Some residents, now aware of the legal realities, urged the board to negotiate in good faith. Others doubled down, insisting that any compromise would be a sign of weakness. The HOA responded by raising dues to cover mounting legal expenses, framing the increase as a necessary defense against an external threat. Lawsuits have a way of clarifying priorities, and in this case, the priority was no longer harmony but control. The association's most consequential misstep came when they authorized the construction of additional AIWDs, docks, and a small marina extension without approval. The project was pitched as a revenue-generating improvement, something that would offset legal costs and demonstrate the board's confidence. From my perspective, it was an unambiguous violation. My attorneys moved quickly, filing for injunctive relief. The court granted a temporary halt within days, citing the likelihood of irreparable harm and the strength of my underlying claim. That injunction changed everything. For the first time, the HOA's authority was visibly limited. Construction stopped midstream, pilings jutting from the water like punctuation marks in an unfinished sentence. Residents who had supported the expansion began asking uncomfortable questions about how the board could have approved such a project without securing the PHL, the necessary rights. Confidence gave way to confusion, and confusion to doubt. Behind closed doors, the board debated its options. Settlement offers were discussed, then rejected. It's often on the grounds that conceding now would expose the association to lawsuits from homeowners who had been promised unrestricted lake access. It was a trap of their own making. Every step they took to assert control increased their potential liability. Every refusal to acknowledge reality narrowed their path forward. By the end of the second year, legal fees had ballooned, reserves were depleted, and the once unified board was fracturing under the strain. Resignations followed, announced tersely and without explanation. New members stepped in, inheriting a conflict already spiraling beyond easy resolution. Through it all, the lake remained deceptively calm, reflecting skies and seasons with indifference to human dispute. What struck me most during this period was how predictably the overreach unfolded. Each escalation was justified internally as a necessary response to my intransigence, yet each one pushed the HOA further from a defensible position. Power, when exercised without legitimacy, tends to rely on momentum. When that momentum is interrupted by law, by evidence, by a refusal to yield, it collapses faster than anyone expects. As the case moved toward trial, it was clear that the association was no longer fighting to win so much as fighting to avoid admitting how wrong it had been. Pride had replaced prudence. The question was no longer whether the HOA had overreached, but how much that overreach would ultimately cost them. And with every filing, every hearing, every dollar spent asserting control they did not possess, the answer grew heavier and harder to escape. The trial began not with drama, but with fatigue. By the time we entered the courtroom, the case had already consumed years of motions, hearings, and procedural skirmishes. The HOA's legal team looked strained, their confidence dulled by attrition. They had once relied on volume of filings, of arguments, of asserted authority, but volume is a poor substitute for substance. The judge, a methodical woman with little patience for theatrics, made it clear from the outset that this court would be governed by statutes, precedent, and evidence, not sentiment or lifestyle expectations. The HOA opened by reframing the dispute as a conflict between private control and community welfare. Their attorneys spoke at length about families, traditions, and the economic ecosystem built around the lake. They described children learning to swim, retirees fishing at dawn, and the development's reliance on the water as its central amenity. It was a compelling narrative, carefully constructed to suggest that my position was not merely legalistic but harmful. What they could not do, what they conspicuously avoided, was explain how any of that translated into lawful ownership or control. When it was our turn, the shift was immediate. My counsel did not speak about feelings or fairness. He spoke about deeds, permits, statutes, and the historical separation between land ownership and water rights in this state. He laid out the chain of title with precision, tracing the rights from their original grant through each lawful transfer until they reached me. Exhibits were introduced slowly, deliberately, each one reinforcing the same point. The rights existed independently of the HOA and always had. The judge asked questions early and often. She pressed the HOA's witnesses on specifics they had long avoided. When did the association first verify ownership of the water? Which governing documents explicitly transferred control? Under what authority had they approved expanded withdrawals and construction? The answers were hesitant, often circular. More than once, a witness deferred to custom or common understanding, only to be reminded that common understanding does not appear in the statute books. The most damaging testimony came from former board members, subpoenaed after their private emails surfaced during discovery. On the stand, stripped of collective reassurance, they acknowledged that the issue of water rights had been discussed internally for years. One admitted that the board had decided against purchasing the rights because it would raise questions we didn't want homeowners asking. Another conceded that legal counsel had warned them the association's position was weak, advice they chose not to document formally. Those admissions hung in the courtroom like smoke. They transformed the narrative from a good faith misunderstanding into something far less defensible. A calculated gamble that no one would ever force a reckoning. The judge's expression did not change, but her questions sharpened. Intent matters in equity, and the HOA's intent was becoming painfully clear. Midway through the trial, the court addressed the injunction that had halted construction. The HOA argued that the pause had caused significant financial harm and should be lifted pending final judgment. My attorneys countered with evidence of unauthorized expansion and increased withdrawals during the very period when the association claimed restraint. Meter records, satellite images, and contractor invoices told a story the HOA could not reconcile. The judge denied the motion without hesitation. As days passed, the imbalance between the cases widened. Where the HOA relied on testimony, we relied on documentation. Where they argued inevitability, we argued law. The association's central theory that long use had ripened into control collapsed under scrutiny. Prescriptive rights, the judge noted, require open, notorious adverse use. The HOA's own records showed repeated acknowledgments of permission and limitation. You cannot quietly accept conditions for decades and later claim adversity when it becomes inconvenient. Closing arguments were brief. There was little left to say. The HOA urged the court to consider the practical realities of dismantling decades of assumed control. My counsel responded with a simple proposition: practical realities do not override legal realities. And courts exist precisely to correct situations where assumption has outpaced authority. The ruling came weeks later, delivered in writing rather than from the bench. was thorough, unsparing, and unambiguous. The court declared that the water rights belonged exclusively to me, that the HOA had no legal authority to control, allocate, or profit from the lake's water without my consent, and that their actions over the past several years constituted knowing overreach. The association was ordered to dismantle unauthorized structures, restore affected areas, and compensate for damages related to unlawful use. More consequential than the remedies was the language. The judge wrote that the HOA had substituted assumption for diligence and power for permission, and that such behavior, left unchecked, would undermine the very framework of property law. It was a rebuke not just of actions, but of attitude. The fallout was immediate. Lenders took notice. Insurers reevaluated risk. Homeowners, now fully aware that the lake access they believed guaranteed was conditional at best, began asking hard questions about misrepresentation. Several filed suit against the association, alleging that they had paid premiums for rights that never existed. The board, already weakened, could not withstand the pressure. Within months, the HOA's financial position deteriorated beyond recovery. Special assessments were proposed and rejected. Dues went unpaid. Essential services were cut back. Eventually, the association entered receivership, its authority suspended, and its assets placed under external management. What had once been a powerful, self-assured institution was reduced to a cautionary example cited in legal seminars. For me, the victory was strangely quiet. There was no celebration, no sense of triumph. Standing by the lake after the decision, I felt only a sober clarity. The water moved as it always had, indifferent to rulings and repercussions. The law had spoken, but nature remained unchanged. The case did not end the conflict so much as redefine it. Control had been clarified, lines redrawn. What remained was the question of what to do next with the lake, with the community that surrounded it, and with the responsibility that came from winning something I had never sought. The HOA had lost everything it tried to take by force.
Ow.
What came after would determine whether anything could be rebuilt on more honest ground. The collapse of the homeowners association did not happen all at once. It unraveled the way tightly wound things often do, slowly at first, then all at once. Receivership stripped the board of its authority, placing familiar names with court-appointed managers whose only mandate was stabilization, not vision. The rules that had once governed everything from lawn height to lake access lost their force overnight. For residents, the change was disorienting. For years, the HOA had functioned as a proxy for certainty, an institution that promised order and protection in exchange for compliance. Without it, the community was left to confront how much of that certainty had been an illusion. Property values dipped almost immediately. Listings began to emphasize interior upgrades and proximity to town rather than lake privileges. Real estate disclosures grew longer and more cautious, outlining the distinction between shoreline access and water rights in careful, lawyerly language. Buyers asked questions that should have been asked years earlier. Some walked away. Others negotiated hard, pricing uncertainty into their offers. The lake, once marketed as the unquestioned centerpiece of the development, became a qualified feature, beautiful, but bounded. Lawsuits from homeowners followed the association into its final months. Allegations of misrepresentation, breach of fiduciary duty, and negligent governance piled up, each one tracing back to the same decision to treat assumption as fact. Settlements drained what little remained of the HOA's reserves. Insurance covered some claims, but not the ones rooted in knowing misconduct. By the time the receivership concluded, the association existed mostly on paper, its original mission unrecognizable. Throughout this period, I was often cast as the villain in casual retellings of the story. It was easier, I suppose, to blame an individual than to accept that the institution meant to protect them had failed. I understood the impulse. Law seeks a face. But gradually, as court documents circulated and judgments became public record, the narrative shifted. What emerged was not a story of an heir denying access, but of a board that had overpromised and under-verified, selling certainty they did not own. With authority clarified, the practical question returned: what should be done with the lake? Legally, I could restrict access entirely, license usage selectively, or sell the rights to a third party. Each option came with consequences. Restriction would inflame tensions. sale would likely invite commercial exploitation. Doing nothing would simply defer the problem. Harold's journals weighed on me during this time. He had not preserved the rights to extract maximum profit, but to prevent misuse. That distinction mattered. I chose a path that balanced control with access. New framework was established independent of the defunct HOA, allowing shoreline owners limited renewable licenses for recreational use under clear conditions. Water withdrawal was capped. Environmental monitoring was formalized. Enforcement, once arbitrary, became transparent and tied to objective standards. It was not perfect, and it pleased no one entirely, which I took as a sign it might be fair. The lake began to heal in small, observable ways. Reduced withdrawals, stabilized water levels during peak summer months. Shoreline vegetation recovered where unauthorized construction had been removed. Wildlife returned to areas long disturbed by constant activity. These changes were subtle, but they reinforced a truth often ignored in development-driven conflicts. Resources respond to restraint as much as to care. Personally, the experience altered my understanding of ownership. I had always thought of property as static, a thing you possess or do not. What I learned was that ownership is relational. It exists within systems of law, ecology, and community expectation. When those systems fall out of alignment, conflict is inevitable. The HOA had tried to collapse that complexity into a single assertion of control. The law forced it back open. I still visit the lake, though less often now. When I do, I see it differently, not as an asset or a battleground, but as something temporarily under my stewardship. The surface looks the same as it did on my first visit, reflecting sky and season without commentary. Beneath that surface lies a record of assumptions tested and corrected, of power exercised and restrained. The story ends without a clear villain or hero, which feels appropriate. The HOA lost everything it overreached for, not because it was punished, but because it misunderstood the limits of its authority. I gained something I never sought and learned the weight that comes with it. Inheritance, I discovered, is not about what you receive, but what you are willing to defend and how carefully you choose to do so.